Court does call the case, People versus Angel Wilson.
Assistant Public Defender Natalie Pate for Ms. Wilson, who is approaching. Please state your name for the record, ma'am.
Angel Wilson.
Okay. What are we doing?
Your Honor, there is a resolution in this matter to which Ms. Wilson will be pleading to added count 2 of operating while visibly impaired, and in exchange, count 1 will be dismissed.
That's an operating while visibly impaired.
That is correct.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Angel Wilson.
Then this is court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor. It is punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services, order any rehabilitative services or community service the court deems necessary. You understand that?
Yes.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
Yes?
Yes.
All right. You signed an advice of rights form today?
Yes.
Any question regarding any of those rights? Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation?
No.
Are you on parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense? August 7, 2023, at the location of US 23 near Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes.
What did you have and how much?
I don't.
You don't remember?
How much alcohol?
Okay, how much?
No.
What did you have?
Tequila.
Tequila? Were you stopped by the police or was there an accident?
An accident.
What happened?
The car rolled over.
Pardon?
The
You need
car.
to speak up, young lady.
The car rolled over on the freeway.
All right. That didn't spontaneously happen. What did you do?
I lost control of the vehicle.
And you rolled it.
Yes.
Did the police and paramedics arrive?
Yes.
Were you taken to the hospital?
Yes.
Were you given a blood test?
Yes.
What were the results?
That I don't.
Was it 0.84?
The defense would stipulate to 0.84, Your Honor.
Do you have any reason to dispute those blood test results?
Me? No.
Yes. No? Go ahead. Do you have any reason to dispute at all those blood test results?
Oh, yes. I do agree.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 10th at 9 a.m.
July 10th, 2024, 9 a.m. I have another bond violation.
Yes, Your Honor, and I have discussed that with Ms. Wilson. She does, and I have then reached out to Community Corrections and then got the actual SCRAM report from that company. I did discuss it in detail with Ms. Wilson. She does dispute both drinking and a tamper. She did provide me proof that she was at work as a CNA during that time. Further, both in the bond violation report I received from SCRAM, as well as my client confirmed, she received a new SCRAM tether on May 28th due to it was either a software update or some sort of malfunction. She had 0 violations for the entire month of May. She got a new tether on May 28th. And then on May 31st, there was an alleged tamper that started at, I believe it was 7:10 a.m. in the morning and stopped at 10:29 at night. During that time, my client was at work from 6:54 a.m. to 3 p.m. She denies drinking
What time did the accident happen?
I'm sorry?
The offense, what time was she at work there at that point too?
No, Your Honor. It was at 4:20 a.m. was when law enforcement arrived on scene.
So early morning doesn't really matter, does it, count?
She was at work, Your Honor, and did provide me a screenshot that she clocked into work at 6:54 a.m.
And so, go ahead, I'll let you go.
We would be requesting a formal hearing as to the bond violation. If the
Okay,
court
she'll
is-
get her hearing, but she's gonna be remanded pending that. I mean, I already have had a violation in this case.
I understand that, Your Honor, and I understand she was remanded and served 5 days for that back in April. She denies alcohol use. Quite frankly, I do believe her, and I believe that this may be a malfunction with SCRAM. She did receive this new tether just on the 28th, and the 31st is when the alleged tamper occurred, and the alleged tamper ended at 10:39 p.m. at night. She still has the SCRAM tether on. There has been no further alleged tamper. Further, she has been to urgent care this week due to a medical issue that I won't go into too much detail with. I did provide a copy of the doctor's note that she received from that urgent care to Your Honor. We would respectfully request that if the court is leaning towards taking any action, that we set this for a bond violation hearing and that bond continue in the interim. She did enter a plea in this.
That would be fine, counsel, except for the fact that I'm now on my second violation, both involving alcohol. You want me to ignore the fact that the original incident was one where she was drinking, rolled a vehicle. She's lucky to be alive. Then I put her on this. She comes for this charge. She's drinking. She serves her time for drinking. I'm back and I now have another violation.
Yes, Your Honor.
How, in what responsible world would I let her bond just continue pending a year?
She denies alcohol use, and we believe it is a tether malfunction, and you're asking for a hearing on the matter. She did enter a plea for this underlying offense and the alleged incident, and she is willing to face penalties for that.
Yeah, because, well, give me the in custody sentencing date, first of all. Changing your sentencing date, what?
June 25th at 9 a.m.
Sentencing will be June 25th, 2024 at 9 a.m. We will move that up. Got a time for a bond hearing I can do. The 25th, my bond hearing date. That's my date that I have. Right.
The 25th is the sentencing. Yeah.
Well, but the 24th, we have trials and
Yes.
right. We'll set a bond hearing on this matter for June 24th, 2024, 9 a.m. Pending the hearing, will be set in the amount of 10,000, make it 5,000 cash.
As this hearing comes to a close, one lesson stands above everything else. Courts don't judge a single event in isolation. They look at the entire pattern of behavior. Even when the defense raises legitimate questions about technology or possible equipment failures, the judge must decide whether the defendant has earned the court's trust. In this case, Prior violations and the seriousness of the original offense carried significant weight. It's a reminder that accountability, credibility, and consistency often influence judicial decisions just as much as the legal arguments themselves. But what do you think? Did the judge make the right call by revoking bond? Or should the alleged SCRAM malfunction have earned the defendant another chance? Let us know in the comments below.